thing I wanted to ask to both defense counsel, or all the defense counsel rather. Now that the state has filed some responses, was there any desire to file replies to their responses?
Your Honor, as to the RICO issue, we wanted to present with some not kind of clear. Are you saying there's going to be an argument to the motions that were filed?
Which motion would this one be? Because there's a couple of RICO motions.
The continuity one won't need a witness. The first one regards to motivation of
Please. Please.
And what kind of witness would this be? Is this like a legal opinion you're trying to submit, or?
Senator Clayton wrote the statute in 1997.
Yeah.
I hear you. I'm going to feed you right now while these guys talk.
Right now, hundreds of cases will come up. They're all checked from.
No, I understand. I understand your argument, and
Good morning.
we were going to dig into that. It's just it seems a bit novel to me on a demur to be hearing live testimony, and so that'll be something we have to think through here. I think it's also something you could potentially submit simply as an affidavit. I don't know if we need a full-blown hearing on a demur.
I do the affidavit. I just didn't know if the government were cross-examining. The reason is we're in uncharted territory with this RICO issue, and so we, unlike most 99% of our statutes, you don't actually have a code section within a code section saying this is why we're doing this statute. So the man that wrote it, Ray, federal judge, obviously he's not coming, but Senator Clay was the other one that co-authored it with him, and he agreed to come and answer those questions as far as legislative intent, what the point of RICO was at the time.
No, it's an interesting argument. He wasn't the only one that voted on it. So you're also going to bring the governor that signed it and the, 50 other senators that voted on it. Then even then, I think we're getting into areas that our Supreme Court has said legislative intent is fairly irrelevant. We're supposed to look at the plain meaning of the statute. So.
Right, but my point, this isn't necessarily intent, Your Honor, because it's actually the statute as the code section. This isn't the notes at the end of the Westlaw, and so I thought.
So we read the statute and we go from there. I think even if you bring in the person who wrote every word of it, it seems to me the initial reaction is that's pretty much completely irrelevant. But we'll see. Let me keep looking at that. I'll note that you want a live testimony on the demur for the RICO. Were there others that you said you contend should be an evidentiary hearing?
No, just the RICO was going to be the evidentiary hearing. The others are just an understanding of what ECA means, but I'd like to have oral argument because it's not quite as simple as some of the responses from the government.
Okay.
Especially as it comes to some of the demurs we followed in the substantive counts, Your Honor. Because if ECA authorizes certain things, then even if it says we listed the elements in their brief, they don't cite the Jackson case from the Georgia Supreme Court from 2018 that says you got to do a lot more than just cite the elements of those things. And so I'd like to be able to discuss that as well. They're not going to be long briefs, but I'd like to be able to perfect the record.
When you talk about briefs, does that mean you'd like to file a reply brief to some of these?
I'd like to be heard instead of burying it in paper. I think in 10 minutes on each side, I can go over what the Jackson case is and wasn't cited by the state as to what is required for a demur. It's not you can say, hey, we listed the elements and shoot on that. That's not how it works. And so I just want to be able to sort of flesh that out over a very short argument if we're going to do multiple motions in one day. And I think it just helps you perfect the record versus filing paper, not filing paper, and then you're stuck reading a lot of this stuff because.
Well, no, I think I don't mind reading at all. It kind of comes with the territory. And in fact, I think sometimes that can be more helpful instead of me frantically writing down all the sites that you're throwing at me. So I'd appreciate a written response, especially if it's just kind of a overarching kind of umbrella to why the demurs maybe aren't as straightforward as the state is saying. So
I know the attorneys are really loud.
Yeah, how much time do you think you'd need?
I can try to get it done. We're trying to get the jury questionnaire together. We've got 178 witnesses on the list. I think your standing order says don't do a phone book method give us the real witnesses that you're gonna call, so at some
Hi,
point. I'm spinning my
butterflies.
wheels trying to track down a lot
No
of people,
worries.
so
We'll see how long it
I'm just
goes.
asking if I could have 10
Ted,
minutes to
hi,
argue
Ted.
versus write, and just, we're down to 3 weeks before we theoretically start jury selection. And we better review the questionnaires once they get filled out
I'm-
over a weekend, like 450 of them. I mean, we've got to.
Oh, let me do this. Hold on. Sorry.
So I just.
Well, you're not going to get too much sympathy from me, Mr. Aurora. I mean, this is a timeline that you signed up for, and I'm happy to give it to you, and we'll make it happen. But
Your Honor, if you want responses, can we have, let's say today is Friday. I mean, can we have a week?
yeah, that's fine. The next hearing date I had flagged was potentially October 9th. I believe that's a Monday, if I'm not mistaken. I have to double check the calendar again. But we could flag October 9th for an argument date for some more of these substantive demurs, especially the RICO counts.
Please don't get me wrong. I'm not disagreeing with my co-counsel. I totally agree that we would like oral argument, but the courts seems to be making clear they want a written response. So I'm just trying to figure out as much time as we can get. So if we can have a week, I think we can make it happen. But if, as my co-counsel said, if you might just at least take under advisement the possibility of giving us some time in the courtroom, we'd certainly appreciate it.
Well, just the reality is that, a written response, especially if you're saying this is more than what the state has responded, then it's going to give me, it might make the oral hearing actually more productive if I can respond and ask questions. So I'd rather make all of our time more productive.
Yeah. So
all
why don't
right,
you do
so
your work?
Let's
Do
flag
your
10-9 as a motions date for some of these RICO demurs. And if you
Oh, I hate that sound.
double check what calendar date that
That
is.
sound freaks me out.
October 6th. Friday.
Okay, it's a Friday. Or no, October 9th looks like a Monday to me.
Yeah, it
I
is a
guess
Monday.
what Mr. Grubman was suggesting, replies.
All right, replies by the 6th.
Friday.
Yeah, fair enough. Okay, so if you've got responses to the RICO demurs, I would say 10-6 would be the time to get them in. And again, we'll tentatively set a hearing, oral hearing on those on 10-9. And similarly, I think the motions that both parties joined on the Supremacy Clause and First Amendment and your reply briefs desired there.
To the extent that we would file a reply, Your Honor, we'll have those as well by October 6th.
Look at him. He's like, duck lips. Yeah.
I'd like to see what the responses said. So I'm still going to have other motions state that we can flag 10-16, 10-17, 10-18. I think that's going to be, I would just block all three of those days.
I'm really worried I made my
or,
coffee too weak.
Kind of our catch-all arguments and last minute motions and things that are coming up. So I think that's probably the cleanest way to do it. So any responses that the defense wants to file in writing, those are all going to be due by 10-6, close of business.
These calendars, huh?
And if you can provide us courtesy copies
Do
as
these
well.
courtrooms come up with calendars where they tell
And-
people what's going to happen? Anybody?
All right.
Anybody?
And we'll just have to, we'll go through them and we'll keep you updated on which
I
ones
don't
we
mind
think.
being up early if,
I mean, some
or
of these,
you know,
again, as we dig
streaming
into
early. I'm
them,
up anyway, but
they decide
streaming.
that the issues are clear enough.
If I know
that certainly
when.
was my reaction to the search warrant immunity motion. Some of these may be the same way, and we'll keep you updated as we move along. Anything else, just in general, in the motions practice that's coming up?
Your Honor, I had a question about the earlier motions filed regarding the grand jury
Yes, sir.
and status of that.
So do anticipate that some of those questions are going to be appropriate. Now we're just logistically trying to figure out how we begin the process of reaching out to the grand jurors.
Okay, thank you.
And we'll follow up.
They can't wait. They can't wait to get their
obviously
hands
tell you
on the
any
jurors
questions
and
we're
make
gonna be able to
them
go forward with,
and terrorize them.
how logistically we're gonna do that. So
Watch.
still on
Watch.
our radar, still working through it.
Ridiculous.
Anything else?
Wow, he really wants to get to breakfast.
Okay. So the next thing, just generally in the case management scheduling order, is disposition without a trial. So
think
all I
his,
would generally ask here is,
I think his
state
Starbucks is
planning
getting
to
cold.
convey any offers in this case. I won't ask I don't need to know the specifics or the substance of them. I would note that before we kick off a trial, we'll make that a part of the record in terms of the history of offers and whether they've been rejected or accepted. But I do try to flag that in case management just to ask the state at this phase that if an offer is going to be made, that it be conveyed at this point.
Judge, we understand. We have not made an offer. Most of our communication with defense counsel has been surrounding the motions and discovery issues, but we have not at this point made an offer.
Is the state in a position to be able to make one in the near future?
Judge, I believe that we can. We'll sit down and kind of put some things together, and we'll reach out to defense counsel individually to extend it off.
All right. Thank you, Mr. Wade. I think that's really all it's more of a check mark on the to-do list here, unless anyone wants to add anything else. But generally what I'm trying to avoid there is we show up for jury selection and all of a sudden there's a lot of back and forth and flurrying of needing to get approvals and that sort of thing. So I'd like to iron that out so we can start fresh when we start talking to jurors. Okay, moving on. I'll just flag that again in the case management to-do list, we make a note of expert testimony. I imagine there's going to be a lot of it here. We say in the case management order that
not as much
it's
as you
supposed to
think.
be turned over 14 days before it's used or before the hearing. I think in this case, it would be more appropriate just to add that and make it a part of the witness list. So 10 days in advance of trial for the state. And that includes not just the name, but CVs and a meaningful summary of what the testimony would be, just so we're all on the same page of who's going to be tendered as an expert and generally what topics are going to be covered. Is that fairly straightforward? Anyone want to add anything on that?
Is there a date, Your Honor, that the court has in mind for defense experts?
Again, I think we'd stick to the witness statement statute. So if the state's witness list is due 10 days before trial, the defense's is due 5 days.
Thank you.
Understood, Judge. Thank you.
All right, good deal. Okay, and then I think the last thing I had before I again turn it over to you all to see if there's anything else would be just starting to again talk through the logistical issues of how, when we kick this thing off, how voir dire is going to go. As y'all probably saw on the docket, we're actually officially kicking it off on a Friday on October 20th, and that was simply because to get that many jurors in a room, Friday is the only way we can do it rather than a Monday, because this would be the only case having jurors come in that day. And as I might have mentioned at the last hearing, the idea on Friday would simply be the jury questionnaire day, where we would start off all going up to the 7th floor where the jury convocation room is, and everyone would be seated there. So I'd encourage you all to take a look at that area before we start the trial. There is kind of it's almost shaped like an L. So there will be a section of jurors kind of around the corner almost, but there would be a live feed where they can see us and everyone would be free to get up and wander around and, be able to observe whatever they need to do. But the idea would be we start off, it's kind of the standard
How many
introductions.
jurors are they gonna October 20th?
We summarize the
Hi,
indictment.
how are you?
Not planning to read it in its entirety. I think the case law supports that. So, Mr. Wade, one of the things to throw on the to-do list would be, I would ask you to write out exactly in a paragraph or two how you're planning to summarize this indictment. And then that's something we can be passing back and forth to see if there are objections to the way it's characterized and make sure that's not something we're just winging the day of. And then from there, we'd give the standard preliminary remarks, pass out the questionnaires.
Trial
for
on
the next
Monday
couple
with
hours.
Judge
We can sit there
Angeron
and
in the
watch
Supreme
everyone
Court,
fill
New
them
York, denied.
And that would be it for the
Denied
day.
Trump's request. Yeah.
And we would collect those and we'd immediately start scanning them in. And what we're working on is trying to get everyone access to a shared drive. So as they're scanned in, we then have access to them. And we would try to make those, we'd have those go in order of juror numbers. So you're not going to get all 400 scanned in the first day, but at a minimum, I would think you'd have the first 25 so that leading up to day one of individual voir dire,
400.
you'd at
Okay.
least got that
Check
day's
it out. It's
worth of
illegal.
juror
Okay, I will,
questionnaires that you can
butterflies.
prepare for. And we would just, on a rolling basis, keep adding those questionnaires for you to access. And moving on to individual questioning, that would be over in the courtroom here in 5A. And the plan right now is again, this all may change depending on how things go and logistically how we're able to use our time. But we start at 9 a.m. with a panel of 14, bringing them in individually one by one. And I'll probably go into hardships
I
based
think
on
they
what's on their
should,
questionnaire.
they should play
and then turn it over
Simon
to
Says.
the parties. And when we turn it over to you, we're going
It'll
to
be faster.
incorporate some of the federal model here. And the plan is that we're going to have some clocks installed on the wall, some digital clocks. Each party is going to have an hour for that panel. And however you want to use that hour is completely up to you. But once your hour is over, your questions for that panel are done. And we'll rotate which party starts off the questioning for each individual juror, just so one particular party isn't always having to go first. So that's and then we would do strikes for cause or favor after each panel of 14. And we do one panel of 14 in the morning. If we're able to get to that and through it by lunch, another panel of 14 is waiting for us in the afternoon. And we repeat until we see how many we're able to qualify and what our burn rate is. So that's the plan of attack right now, open to input from any party. Mr. Rafford.
Yes. When you say an hour, is that an hour to be shared between counsel for Mr. Cheesebro and counsel for Ms. Powell?
No, each defense counsel would get their own hour.
Okay, thank you.
Your Honor, one other thing, I haven't followed this yet, but would you consider providing extra strikes, because theoretically we have to share the 9 with Ms. Powell? I hadn't done that, but I didn't know if you wanted to do it as far as giving us 2 extra strikes. Just
You can
Oh,
you can
thank
file a
you,
motion,
Gal.
and I don't think that's something I'm going to rule on before jury selection, though. That's something I'll take up when we're in the thick of it and we see how we're doing. The initial reaction would be, like I said, going off the severance motion, I don't think there are antagonistic defenses here, and it sounds like that might be something y'all are able to collaborate on and share. But I'd be willing to hear your arguments when we get into it. So just to preserve the issue, feel free to file a motion.
All right, and you said after the 14, we're just doing challenges for cause at that point, until we get whatever.
That's right. Depending on the timing, if we're not through with that first panel of 14 until 1 o'clock, we're just going to have to bring in the next panel, and we'll save all of the challenges at the end of the day. So ideally, we do them in between when it's fresh, but we're just going to have to see how things go.
How many alternates is your Honor planning on having?
I think we'd be shooting for around 6.
And are you, in your opening remarks, going to be saying this trial is going to be 6 months or whatever, since you're going to do hardship questions and jurors on those?
Yeah, no, it's a good question. I'll distribute the script that I'm planning to read from for those introductory remarks, and so we can all kind of work through what we think is accurate there. But my plan was to say 3 to 5, and take it from there. And I would be telling everyone, since there's a lot of travel over Thanksgiving and
I
the
think he
holidays,
is. I think
we'd likely be taking
I
off the
think
week
it's
of
the one mic
Thanksgiving.
in a jar.
We'd likely be taking off the last 2 weeks of December. And we'd also probably be doing Fridays off. So it'd be full days, at least 9 to 5, Monday through Thursday, and then accommodating those holiday periods. And I think that's still going to give us a lot of productive time each week to get into everything. But the plan, to answer your original question, was to inform that it'd be 3 to 5 months. And if there's any other thoughts there, though, happy to hear them.
One other question, if your Honor is going to have Thanksgiving that Monday or Friday off, and then 2 weeks before Christmas, it impacts some of the other cases of that. So would your Honor issue something saying like from the 17th of December until the 1st, I guess?
Oh, brother.
2 weeks is all.
Yeah, he will.
I just don't want any conflict issues.
Fucking idiot.
I'm not tracking. So you're worried you're going to get called in on another case, like during those 2 weeks of December?
There's a few other things I need to deal with, but super serious. I would like to deal with them. So if you're saying that we will be taking the last 2 weeks of December off, I'd like to sort of iron that down firmly now so I can plan for that, because I'd like to be able to handle that person's case so they're not just languishing, where they are. So if we've got 2 weeks off, I can take care of some business over that break.
Okay.
Saying absolutely we'll do that so I can play it, or if you're saying you're thinking.
So since that's still I think I'm planning to tell the jurors that. So let me make sure that we've ironed this down and this is the way we want to go. But if you need something in writing, we can work through that. We can talk about it. But I don't see a need to fit in a day or two here. I anticipate we're going to lose a lot of jurors if we try to work through those 2 weeks. So I don't really see why getting a day or two in there I don't see that being worthwhile.
I don't need it in writing. If you're just saying we'll have the last 2 weeks off, I can go ahead and file conflict on something I want to resolve starting on the 18th.
Sure. Any input from the state on this? Just kind of some of these logistical voir dire issues we've laid out.
Judge, I don't think we have any objection to what the court's laid out. That sounds good to us.
Okay. Mr. Rafferty, any thoughts on the process other than, we talked about the hour per party?
No, Your Honor. The only other question I had is, you mentioned some kind of summary of the case that you're going to read on Friday the 20th. In some cases in federal court, the judges will entertain not just a summary of the
The
indictment,
only people
but
who
a
would pay
summary
jurors
of
definitely
the
don't want you
defendant's
there. Yeah.
contentions. Would the court consider at least
I
looking
would
at
pay
the
to be on the
defendant's
jury.
contentions about this so that the jury or
I was
veneer
thinking how
not just
exciting
going
this
to be
would
hearing
be.
what the government has obtained in the form of an indictment, but what the defendants say in response.
Certainly would consider it. Just again, the
You know
idea
what?
here is
Why don't
not
you
to.
fucking
I would think you could handle that
Shut
in a sentence or two. And if that's what it is, then
Sure.
I'm not seeing why that would cause any issues. If it's simply Ms. Powell contends that she had nothing to do with this, and if she did, she had authorization. That would be more like, I think, the civil standard, how they kick it off. But again, the idea is that we're not summarizing our entire case. The government can say this is a RICO case. These are all the people that are charged. These are the 2 specific people that are here today, and here's what they've been charged with. And I'll certainly consider if you want to add on a sentence or 2 at the end saying the defense, however, says this.
Thank you.
But we can take that as we get closer and work on that script. Mr. Wade, I think you want to weigh in here?
Judge, our understanding of what the court was describing was simply just kind of an outline of what the indictment says, not so much
a
as
testimony. Yeah.
the state putting on its actual theory of the allegations, and I think that counsel's
Sir, the allegations are the theory.
recommendation
Hi,
to the
Jim.
court is essentially
Oh yeah,
him wanting to
Melania
put his
is she
defense,
renegotiated her post-nup.
forward in this summation, if you will.
Oh yeah, Miss Powell
and I
had
just think
So
that
much
probably
to
goes
do with
beyond
this.
well, the court's request. We certainly would have an objection to that happening.
Yeah, no, that's a fair point, Mr. Wade. Let's see. I'll think on it. Let me double check the case law on this and the pattern instructions of what the intent is. Why we
Excuse
do this
me,
anyway.
but the jury
I think
instructions
generally
need to be
we're doing
clear.
it to let the jurors just know.
Okay.
Hey, what is this case and what's it about?
Oh, he
So that
is?
we can qualify them. But you raise a good point that we
I don't
shouldn't
get
really
it.
be getting into the issues per se necessarily.
get
So
it.
it's a good issue to flag, and we'll keep working on it as we move forward to the 20th.
This is so weird.
That, I think, is everything I had to talk about for voir dire, unless there are any other things that you don't think of.
Your Honor, you gave us dates for the motions, but are we going to get together on the questionnaires to sort of iron out what the questions will be? I'm sure that will take several hours to sort of sit down after we share insights.
Yeah, absolutely. That's why I think we should, I think we had, like I said, I would just block out the 16th, 17th, and 18th. On one of those dates, we'll meet and we'll talk about questionnaires. Based on this morning's experience, I can't promise it'll be over Zoom, but we will find the time. And again, any kind of holdover motions that we think still need a hearing, those will be the dates.
Judge, there is a matter that the state would like the court to address.
Yes, sir.
If it's okay. There are 4 remaining defendants that had not.
I think there's 6 actually. I think there's 6. And today was the day I was planning to check in on them.
Okay, so you know where I was going.
Oh yeah. Anything else?
The other thing, Your Honor, I think some of the lawyers, I saw an email from Mr. Stanfield this morning. I guess there's a couple of these motions that apply to everybody. I didn't know what the court's position would be, because I think you made a good point saying if you rule this way with Mr. Chesbro and Powell, it's going to be hard to reverse it for the others. Would that be something we need to plan for, that other lawyers that have offered motions that are global for everybody?
Understood. Right now, because we have to stay, I think, focused in getting this case ready, handling the logistics of getting everyone here, handling the arguments. I mean, the motions that you adopted, there are certain aspects of them that I think would apply to your client and to Ms. Powell, but wouldn't be as applicable to everyone. So I think that there's going to be a way that I think we're just forced to, based on where we are. The plan is just to decide those motions as they pertain to Mr. Chesbro and as they pertain to Mr. Powell. It wouldn't foreclose their ability to argue them later, and any of the potential legal arguments that
Did he
affect
call her?
them
Did
differently.
he just call her Mr.
So no,
Powell?
the plan is we're
Jury
just going to
questionnaires
stay,
are different than jury instructions.
keep
Yeah,
our-
exactly.
our circle to just who's here now.
Last time they gave
until we
me a
get this
prepaid
trial,
card. What?
taken care
The
of.
jury is paid to be there. Oh, yeah.
Your Honor, I had a few other housekeeping issues. I don't know if there are
Yes,
others.
sir. This is the time.
This is the time. Okay. Initially, what I wanted to ask about is jury instructions. My experience typically is that's something that, my experience is submitted before, at least a draft of the jury instructions are circulated with the parties before the trial commences, before opening statements, so we have a sense of what the law is. And, in federal court, jury instructions are pretty well patterned out. You know what to expect. My cursory review of the state instructions, there's a lot of instructions that, there aren't a lot of instructions for. And so is the court willing to entertain requiring the parties to submit jury instructions maybe by the 23rd of October? We'll be in the midst of jury selection, but we'll at least have a sense before we actually get to opening statements of what the law,
Well,
the parties
isn't that the
contend
day
is,
that
at
start
issue
that they
here.
have to start? State doesn't
Yeah,
want the
that's an
remaining
interesting,
defendants to all of a sudden
point.
request a speedy trial.
Certainly, it would be
Good
the
point.
most efficient way to narrow our focus, but I don't think that's our practice here in Georgia. In fact, I don't have the uniform rules in front of me, but I think the requirement there is simply that they're submitted in writing, and then we have a charge conference. And it's a lot of times we can't actually figure out what instructions are appropriate until we know what the facts are that came out of the trial. So I certainly understand your motivation. I certainly love the appeal to efficiency, but it's a bit of an uncharted request. I'm curious if the state has heard this or had a chance to chew on it, on the idea.
Judge, we've had some discussions about this, and to the court's point, I think some of the charges we might be able to submit to the court ahead of time. But again, as the court pointed out,
Oh, the
many of
judge
them
plays the cello.
will depend
Oh,
on
wow.
what the evidence is. So
Good one.
we would
Good
defer
one,
to,
Jim.
to what the court would like to do. We're ready to do whatever the court instructs us to do. But again, until we hear what the evidence is, I don't know that we can really do a full charge conference.
And Your Honor, I understand that, while it may be uncharted, I understand in state court and federal court across the country, trials happen and jury instructions are typically submitted. And there's, for example, there's an instruction if the defendant testifies. There's an instruction if the defendant doesn't testify. But there are certain instructions here which I think would be valuable to at least see what the parties' views are, the elements of RICO, what the statute says, what's required to prove somebody's participation in a RICO conspiracy. All of these things, I think, they're not written in stone. And I get that at the end of the trial, the judge is going to have a charge conference and will select what the appropriate instruction is. But I think there's value to everyone to get their perspective on what the law is going into the trial. It doesn't marry anybody to it, but I think it will be helpful to everyone.
Yeah, Mr. Rappy, like I said, I think it's a good point, and we do have so much on our plate right now. Again, I don't think I can hold or require any party to submit them. But if we want to get in there and make some preliminary findings saying if the evidence is this, then this charge would likely come in. I mean, we can have that discussion. I don't think I can issue, like I said, a definitive ruling saying this will be the charge that happens. But if we want to have some of those discussions on game, because it does, I think, in the grand run, benefit everyone to know where the focus and where the issues lie. So I'm open to it, but I think it's going to have to, it's in terms of the list of priorities, it's going to fall towards the bottom simply because we may not have time.
Understood. It was just a thought. In terms of the courtroom, has Your Honor decided, are we going to be trying the case in 5A? Is there another courtroom?
Right now, because there's been some other, I think, speedies that have been filed that have more defendants than this one. The intention is we'll be in 5A, that it can hold us if we need to reserve certain rows for extra attorneys or legal assistants or investigators. Let us know if we just need to block out the whole first row or legal teams. But other than that, we also have we have a side room that we could devote to defense counsel's use. Same for the state. We do have some smaller rooms that we could unlock and give you exclusive access to for storing things and the like. But right now the plan is 5A.
Okay.
For all of Bardier and the evidence.
Again, I can't recall how big the room is, but is there a sufficient space in that courtroom to have a second table for the defense side? Because I know we haven't had the defendants in the courtroom with us. It's been pretty sitting there, just the lawyers. Will there be a second table we can have so that for Ms. Powell, we'll have a table and Mr. Cheesebro will have a table?
Let me work on that. I think there should be room to fit one, maybe do like an L shape. And I'll see if we've got one that we can procure.
Thank you. You mentioned conference rooms. That was another request that I had is, obviously we want to be as efficient as we can with our time, lunch breaks, things like that. If we're able to have a room that the defendants could use to store stuff, as you said, have our lunch, have some waters, things like that, we can use
some
that.
cookies
Be back in the
too.
courtroom in a
I
timely manner.
particularly do
so
not
we
like
never
oatmeal
lose
raisin
minute of
cookies
time
because
for
I don't like
jury
the
or-
raisins, but if they were straight
We have
oatmeal
that, and
cookies,
we'll
that
show
would
it
be
to you
fine.
at our next motions hearing, so you can explore that space. It's nothing too extravagant or
Can they
luxurious.
please
but
just not be?
It has a door, and the door works. And that's all I can promise you.
We don't want people to see them.
And then just some other things I just asked the
Where
court
are
to
you
consider.
going? My cat is.
There's going to be a lot of witnesses in this case, and the
Okay,
government has 178 or whatever it is. My experience in a lot of trials, big trials like this, has been the government has been asked to disclose the witnesses for the next day in the morning. So at least we know who to expect the next day, recognizing that things can change. I don't think, there's a lot of value in trial by ambush. If the government knows who they're going to call the next day, I don't see why they could at least give us a heads up so that we know what to expect. And I just asked the court to consider that. It's most of the big federal trials I've had, the judge typically requires the government to do that because it tends to move the case along. So I just would ask the court to consider that. I don't know what the timetable is for the government's disclosure requirements as it relates to exhibits. But same sort of thing, because I think that, once we get their exhibits, I think there may be an ability to reach some stipulations on the admissibility of those records and documents. If we can do that, I think that's also going to move this case along. So I don't know if there's a schedule in place for when the government will be disclosing all of its exhibits, but I think there would be value if we can get them in advance of the 23rd so that we can decide if there are things that, we are going to stipulate to. So we don't need to have custodians of record or anything else coming in. And we can likewise try and get some exhibits to the government to see if we can reach similar kinds of stipulations.
Understood, Mr. Rafferty. Mr. Wade, just on the idea of giving previews of what the next day looks like, obviously it wouldn't be binding and things change and things come up. But just as a professional courtesy, what do you think of that?
Judge, with a backdrop of it not being binding and things do change, the state is not trying to make any attempt to do this trial by ambush thing. We're disclosing everything that we have. We're giving over discovery. We're giving over the witness list. We don't have a problem sharing with defense counsel the witnesses that we plan to call the next day if we can pin it down like that.
Yeah, if you know it.
Fantastic. And then in terms of an exhibit list, that is not something that's generally
Maybe
required
stop defendants from
in advance like a
threatening
witness
witnesses.
list is. Certainly, I always appreciate
Oatmeal and
having
chocolate
one
chip
so
for
I
the
can be
win.
following along and checking
Hi,
off what's been
Spin.
admitted and
How
what
are
has not been.
you?
So for
They want a
now,
green room,
let's
I
just
know.
say I'll leave it to the parties to see
Yeah.
what they can work out amongst themselves.
That's it. You're right,
And
Ted.
again, the
He wants
idea
the
is, I
exhibits
think
to
it
make
serves all of us
small
to be able to proceed
process
efficiently
complaints.
and to focus on the issues at hand.
Delay,
and not be worried about
delay.
authentication or simply, what the number is of this or that and slowing us down. So, Mr. Wade, if you want to add anything about an exhibit list, I certainly think it's a good sentiment, but I don't feel the need to set another deadline for something in so short a time period that's not required by statute.
Nothing to add, Judge. We agree with the court.
All right.
And then the only last issue I asked is with respect to exhibits, is the government going to be producing those in digital form, or are they going to be just paper copies?
So the rule around the courthouse here, and it's sometimes not always enforced as strictly as it should be, but there is supposed to be a digital copy for the court reporter for the record. In terms of what's actually used to hand to a witness or whatnot, I think, we usually will see those in all sorts of forms, but I'll just note that there is supposed to be a digital copy for the court reporter throughout of every exhibit that's tendered. And Mr. Wade.
Judge, I'm told that everything that we have is digital anyway, so no problem.
Judge, do we have technology for that, or are some judges making us do a screen share on Zoom, which is incredibly complicated?
You don't think our experience today has enamored you with our Zoom capabilities? No, that is the setup. Every courtroom has the same setup, and we've had enough trials in the courtroom where once
Ooh,
we
day off. Yeah.
maybe on one of these motion
bleh.
staves, we just let you play around with the
Yeah.
equipment to gain some
Rudy's
confidence
attorney
with it.
filed a motion
But so
to
far in our
drop him. I
trials,
saw that.
more or
Oh
less,
my God.
It's worked,
He
and it's
did.
got the ability
He
to
did,
zoom
Jim.
and mark the screen
He did.
and do whatever you need to do with the exhibits. But
Yay.
throughout the trial, we're all on a collective Zoom
Low
call.
key.
And that, yes, we
I
share
like
our
low-key
screens to be able to
days.
share exhibits. Frankly, I don't think there's any other way now that any of our courtrooms are operating but through that.
What's the Elmo machine?
That's right. No, the Elmo machine is still there. I don't even think it's hooked up to the Zoom capabilities. So we've moved on, for better or worse.
Judge, if we could just go back briefly before we wrap up here. The court reporter issue, was it the court's intent to convey that the state should just share the contact information with the court and then you'll start to push the effort, or how do
Well, I was hoping you could give me a more definitive answer from the court reporter of their position today. So just to be able to contact them today and say, if we requested an expedited transcript, could you make that happen? And when? And if not, can you give me the recording? And based on her response, then get back to us and I'll enter any appropriate order that we have to do.
Yes, sir. Yes, sir.
Okay. And then in terms of other, if we need to recap here in terms of other, the to-do lists, on 10/5 in the afternoon, we'll at a minimum be arguing the discovery motion of Mr. Rafferty. If there are other motions that come up that I think we can add to that, I'll take a look and I'd be happy to hear your thoughts on it. 10/9 or 10/6 would be due date for reply briefs, if any, from the defendants. And then 10/9 would be a date for us to argue some of the demurs related to the RICO counts. We've also got some other dates that we can hold to see what comes up. October 10th and October 11th, those are afternoons we can use as things come up, just FYI. But the 16th, 17th, and 18th are also going to be our dates to be scheduling everything we need to schedule, including questionnaire discussion, because I think the questionnaires would have been submitted by then. Are y'all still planning to do a consolidated one?
On the defense side, we are.
Okay. And let's see. Again, going over a recap. I think we've covered a lot of ground. Okay, anything else from the state?
Judge, with regards to the presence of the clients, can you still use and say all the way out of state?
Yeah, for all the motion hearings, if you've got express permission to waive, the client's present. We'll keep doing that.
Nothing else from the state, Judge. Thank you.
Okay, thank you, Mr. Wade. Anything
I think
else
they should have to
on
show
behalf
up.
of Mr. Chesbro?
Write those
Nothing,
down. What?
Okay. And Ms.
Well,
Pe-
We
I'm
should zoom
sorry,
it
I may
together.
have
Oh,
cut Mr.
yes.
Aurora off. I apologize.
Sure.
We're in different places.
Yes. Yes, we should. Let's do it. Let's do it.
Well, October
I know he
20,
does.
the 20th would be when we're introducing all the parties, all the attorneys. That's when all 450.
I know,
are
I
there.
gotta write those dates down.
Also
I'll go
identify
back
yourself.
to my recording and get those
So
dates.
that would probably be a good chance for your clients to be there. But
No, I didn't realize that. I thought we were just, I will have them there. And then is it 450 or a total of 900 that you're? filing?
it's in stages. So it would be 450. I forgot to cover this. 450 on 1020. We're going to see how the week goes, what the burn rate is, how many we get through, and how many we qualify. And then if we need to do another 450 with questionnaires all over again, that's the next Friday. So if we're on track from that Monday through Thursday of qualifying, 5 or 6 a day, is really all we need to make the deadline. We won't need that Friday, those extra 450. We'll just keep going with that original batch.
Judge, we did have one other thing, forgot to mention. We had filed the notice of potential conflicts a week or two ago.
Sure.
Ask the court how it planned to address that.
So I think Mr. Grubman had filed a response. And Mr. Grubman, I think you'd indicated that there's some documentation you'd be willing to provide the court. If you could email that.
Yeah, and Your Honor, I'm sorry, I really, in my not that many years of experience, usually
In my
a prosecutor
drunken
will
stupor.
give the
Yeah, it's
very
just a pretrial
basic
conference,
professional
J3. Say
courtesy
good
of
morning.
reaching out to ask. Mr. Wade
Could you clean
decided
your,
that was not something
camera,
the state wanted to do in this
sir?
case, which is his prerogative. But yes, I have waivers that I believe are going to satisfy the court. I would argue they are privileged. And so I would ask if the court would like, I will submit them in camera for the court's consideration. I asked Mr. Wade and his team to please pick up the phone next time and call, because I don't think we have to waste the court's time on every little thing. And we certainly will try to return that basic professional courtesy that usually lawyers in the state of Georgia give to one another.
Hey, listen, why
All
don't you
right,
shut
Mr.
the
Grubman.
fuck
So
up?
you would email those over in camera,
Yep.
and I will,
Fuck that
after
guy.
reviewing those, if,
Fuck
I think
that guy.
if there aren't any issues remaining, I'll file a
Dumbass.
very short
I do
order,
like this judge.
noting
do
as
like
much without the substance.
Thank
And I
you.
think that would
You
resolve.
better not take these assholes for granted,
that
though,
issue.
okay?
So, okay, other than that, Mr. Wade or Mr. Wooten?
I think that's all, Judge.
Okay, if you say so, we'll see by the time we get back around. Mr. Aurora?
One silly question. I know.
Oh, go ahead. What you got?
In regards to, we're doing the RICO on the 9th. Are you saying I can call my witness or not, or are you just gonna wait till we have the reply briefs just so I can have a witness available? Or should I just have them on standby? I guess it's very good.
Yeah, let me take it under advisement. My goal is not to waste time because we don't have a lot of it. And if this is just going to be a dead end for you, then I would say submit the affidavit to perfect the record. But we, in terms of live testimony, if it's not going to have any impact on the analysis, then I wouldn't be looking to do a hearing.
And I'm sorry, Judge, I'm begging the court's indulgence. We couldn't hear Mr. Aurora. Who is this? Who's the witness?
Senator Clay. is one of the
Clay.
authors.
Who?
Senator Clay?
So, Mr. Rohr, I'll get back to you on that. And if nothing else, what we could also do is on that particular, I think you said it was the legislative intent, we could have that hearing later after I've been able to read your response and digest it. And we could have the other demurs on 10-9, and we could have that one and on that issue at one of the later dates, like 10-10, 10-11, 10-16, something like that. I mean, obviously, just based on where we are and what's going on, a lot of this is going to have to be touch and go and blanket by ear. All right, I'm not going back to the state. I'm done with Mr. Chesbro and Mr. Rafferty.
I one question, Your Honor. You mentioned there are 5 or 6 other folks that I guess have not indicated one way or the other.
That's right.
all of these dates are obviously with the best of intentions. Somebody else decides that they want to join us on the 23rd. Are we going to have to, and I think you mentioned that people have to make a decision today. Is it possible that we may have another one of these conferences early next week if somebody else decides to opt in?
I think that's quite likely. So I will be checking in with everyone today, and based on the feedback and the response we get, if it dramatically shifts the dynamic, we will make room. And perhaps instead of 2 tables, we'll be getting 3 or 4. We'll see how it goes.
Maybe
But obviously
people will have to
there's
share
gonna be a whole
tables.
analysis
I
that
don't
has to
know.
happen. And
It could happen. Yeah, state senator.
we're taking it day by day.
Understood. That's all I had, Your Honor. Thank you.
Okay. Thank you all. We'll, if nothing else, we'll see you on the 6th.
Thank you.
Thank you,
Thank
Judge.
you, Judge.
Okay. Woo, 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 woo. Cheryl. No. No. Sorry. Hi, kids. How are you doing? I woke up. I haven't had any coffee. I've had 1 hit of pot, weed, whatever you want to call it. And I now need to go drink said coffee. Thank you, Gal, for letting me know. I will write these dates down, Gal. I'll run the video back and take note of the dates. And you know what? I guess you guys are going to see me from 6 a.m. until whenever, beginning when this trial does. So I really hope you're not sick of me. Well, I mean, if you are sick of me, that ship sailed. But I hope you don't get sick of me if you're not already. How about that? All right. Thanks for the short one. I know I totally forgot to get my coffee. I love you. Thank you, Gal, again for giving us a heads up. Gal is always on the job. She was always paying attention, and we are very, very grateful to her for it. All right. Thanks, all. Have a great Friday. Fuck yeah. See you tonight. We're going to have a party. It's the 1-year anniversary of the lounge. Be there. Be square.